We'll now call 125-846 State of Kansas versus Benjamin Ballard. Counsel.
Good morning, and may it please the court. Grace Tran on behalf of the appellant, Mr. Benjamin Ballard. Benjamin was charged with failing to register as a transient offender during the month of September 2021. However, the state's own evidence showed that Benjamin was not actually transient during that month. The state had submitted a form to the jury that showed that Benjamin had put his brother's address as his current physical residence. And also, Benjamin's brother testified that during that month, Benjamin lived with him and he slept on his couch every day. Under Cora's definitions, Benjamin was not transient during that month. He resided at his brother's house. Because of that, Benjamin's conviction should be vacated because the state failed to put on sufficient evidence that Benjamin was transient. But even if
isn't Lena Kastner, the employee who testified, why aren't her statements that he reported that he was transient, that statement alone, that evidence alone, sufficient to put this matter before the jury? I understand the defense would have put on, no, that isn't what the evidence showed, but her statement that he was transient, isn't that prima facie evidence of the...
Your Honor, no, it isn't, because to get there, we have to look at the definitions of transient, residence, and resides in Cora. And the fact that Lena Kastner said that Benjamin told her that he was transient, that doesn't comport with the other evidence that had gotten put forth, which was the fact that at that very same time, he told them, as evidenced by the form, that he was living, his current physical residence was his brother's house. So the fact that Benjamin thought that he was transient, or Lena Kastner thought that he was transient, it's not relevant when the actual evidence that was put forward does not comport with Cora's definition of when someone is transient.
There might have been objections, but none were made. So it came into evidence. So the jury has heard the defendant's own belief that he was transient. And it sounds like there are reasons to impeach that or reasons to explain it away. But the fact that those reasons exist, is that enough to change the sufficiency analysis?
Yes, Your Honor. Our argument is that even with all of the evidence, even with Lena Kastner saying that Benjamin told her he was transient, none of that actually matters because under the statute, he wasn't actually transient. Transient, according to Cora, means that they have no fixed or identifiable residence. And all of the evidence showed that he did, in fact, have a fixed residence. And I think this gets to the difficulty with the definitions of transient, residence, and resides in Cora being different from a common understanding of what we would consider when someone is transient. Because the average person, such as Benjamin, I don't think would consider having 3 different definitions that are all intertwined with each other, 120 words, to describe whether or not they are transient. And so I think it's understandable that Benjamin could have possibly thought that he was transient, and indeed that the jury could have thought that he was transient. But the fact is that under the statute, the evidence did not show that he was transient because the state's evidence showed that he did, in fact, have a fixed and identifiable residence, which was his brother's house.
One other question on that. I know that she testified that he reported that he was transient, but that's kind of a legal conclusion, because what he actually said was, I walk around Broadway and the Lord's Diner, right? I mean, he didn't say, oh, I'm transient, or I don't have a home. He just said, I walk around Broadway and the Lord's Diner. He didn't say where he sleeps, right? Or did she testify that he said, I'm transient?
I believe the testimony is that Lena Kastner says that he reported that he didn't actually, quote, reside at his brother's house and that he did walk around Broadway and the Lord's Diner. But again, I think that using these terms like reside, transient. I think maybe there was other testimony that he said he reported that he was transient. Like you said, those are legal conclusions. And I think.
And one of the places that he said he could be found, besides the Lord's Diner and Broadway, was his brother's address, right? On that same piece of paper.
Right. On that same piece of paper, under the current physical residence, that was what he listed was his residence at that point.
To Chief Lukert's question, does it matter if she was wrong about what he reported if there was no objection?
For the sufficiency of the evidence analysis, I don't think it matters whether there was an objection or not. There doesn't have to be an objection to preserve that when this court is looking, did the state meet its burden to prove beyond a reasonable doubt that he was in fact transient? And when we look at the statute, he has a fixed and identifiable residence, so the state did not meet that burden. There was no evidence to the contrary, legally speaking, that he did not stay, sleep, or maintain his person at his brother's house during that period. And that's what the statutes require.
But can we assume that that's the only place that she got the information if she testifies that this is what he reported? If there's no objection, don't we have to take that as evidence that he said that or that he did that?
I think it's perfectly possible for Benjamin to have reported that he was transient to Lena Kastner. But as Justice Standard said, that's a legal conclusion, whether or not someone is transient. And so I think, so if we imagine the situation in reverse, Kansas appellate courts have said, when an offender has a good faith belief that they do not have to register as an offender, that doesn't matter when we look at that. And so if someone had thought, I don't have to register, we would not be here talking about that today. But I think the same applies in the opposite sense here, where even if Mr. Ballard and Lena Kastner and Deputy Clopton, they all have a good faith belief that Benjamin did have to register as a transient, it still doesn't matter if legally speaking he wasn't transient, and that's what all of the evidence showed. So Benjamin can think he's transient, Lena Kastner can think he's transient, but all of the evidence showed that he lived at his brother's house. He put that down on his form. Nowhere did he say that he did not sleep or maintain himself there for multiple days or parts of days. So all of the evidence showed that he resided at his brother's house during that time period.
And I suspect this question is very intertwined with your second argument about the jury not being properly instructed. But it seems to me that you are really asking us to reweigh evidence because this jury apparently did not find credible the brother's testimony that he was residing with, that his brother was sleeping on his couch, and he considered that to be residing with his family during that time period.
And Your Honor, it's our argument that we are not asking this court to reweigh the testimony. The Court of Appeals did speak a lot to the fact that the jury must have just not believed his brother. It must have been a credibility determination against the brother toward the sheriff's office staff. And Benjamin's contention is that so because it's not a credibility determination because, so like you said, this goes toward the instructional issue, which is that it's incredibly possible that the jury didn't think that John's testimony or the state's evidence, the form, established that Benjamin had a residence because they weren't instructed on the actual legal definition of what is a residence. And so, like I said before, Hora's definitions of transient, of residence, of resides are not common sense toward what the normal average person would think of as a residence. The jury did not hear that if the person stays, sleeps, or maintains their property in a location, they reside there. There's a presumption that they reside somewhere if they stay, sleep, or maintain themselves there for 3 or more consecutive days. So it's quite possible, not necessarily that the jury thought that Benjamin didn't have a residence because they didn't know what residence actually means in this context. And so it's not a credibility determination. It's a legal determination that the evidence presented established a residence, established that Benjamin wasn't transient, but because Hora's definitions are not self-evident to the average person and what they would think of when someone is transient, the jury was not able to adequately weigh that question because they simply did not have the tools. And that goes toward the instructional issue that the jury should have been instructed on those terms because, again, the terms are not, or the statutory definitions in court are not really self-evident. They're very complicated. They're very long. The average person could think, okay, if someone, and as the state's witnesses testified, if someone doesn't have a permanent place to stay or a permanent address, that they could be transient. And it may very well be true that this was not a permanent place to stay or permanent address for Benjamin, but that's not what the statute requires. The statute just requires a fixed or identifiable residence.
Can I ask you a question that may sound a little academic? I'm not even sure I'm not even suggesting it could be outcome determinative here, but I think it's important for criminal appeals in our state. The Court of Appeals looked to whether your requested or the proposed instructional language to be added was legally and factually appropriate. And they concluded it was, right? And that was the test they applied for sort of the error analysis. But our precedent has suggested that when you are dealing with omitted language, you're not going to get every legally and factually appropriate instruction. So we look to the instructions that were given as a whole to see whether they accurately state the law or were likely to mislead the jury. And that's a different error test than when you're talking about assessing instructions that were given for factual and legal appropriateness. Do you think that what I've suggested is the correct legal standard for assessing error with your issue?
I believe so, Your Honor. And I believe in our brief, we argued that sort of along the same veins as we've been speaking, that the jury instructions that were given as a whole didn't adequately represent the law to the jury and were likely to mislead them because, again, the definitions are just not intuitive. They're not common sense definitions that the average person would understand.
Right. The test fits your argument well, but that is the test as opposed to just whether it's factually and legally appropriate. And that alone would demonstrate error. That's not the case, right?
That my understanding is that's the case, Your Honor.
Thanks.
Is there any place in the record that the jury was, through counsel's argument or otherwise, told about the statutory definitions?
There weren't any specific arguments toward the statutory definitions. I do believe one of the state's witnesses had given the jury some definitions that were closer maybe to what the statute requires. Ryan Hansen, I believe of the KBI, said that a transient offender has no known physical address or doesn't have a fixed physical address, which maybe gets us a little bit closer to what the statute says. But in the face of multiple other statements by the state's witnesses, I think that those definitions are outweighed by just the weight of how many times the jury was told definitions of transients that were just not what the statute requires. And I see that I'm out of time. I would stand for any questions.
I see none. Thank you.
Thank you.
Mr. Gillette?
Thank you, Chief Justice. May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I'll take these issues in the order that they were presented in the original brief today, beginning with the sufficiency of the evidence. And it is the state's position still today that the defendant, even from the podium, is continuing to ask this court explicitly to just reweigh the evidence and credit his brother over everything else. And that is not appropriate under this court's standard of review, which requires the court to review the evidence in the light most favorable to the state without conducting such reweighing. Here, the state does believe that the evidence was overwhelming, and I want to summarize that and emphasize one particular point, what the evidence did show. The defendant was required to register as a result of an Arkansas conviction that required him to register once he came to Kansas. He was required to register in the months of January, April, July, and October. In July, the defendant registered as appropriate and had his picture taken. That fact and that evidence was presented to the jury. Prior to August of 2021, the defendant, in fact, did self-report to Ms. Kastner that he was transient and he did not reside at his brother's house, but that he went there during the day.
Can you give me the record site for that? And what is her exact testimony?
I cite in my brief, it's record volume 5, pages 151, 156, 159 to 60, and 165.
And so,
as well as State's Exhibit 2, sorry.
So this is more than, somebody marked him transient in the system. Okay, but when asked about that, this is more than what he wrote locations where he could be found during the day.
I want to back you up one step because that was the next point that I want to emphasize.
Okay.
Why was he there in August? If he's not transient, August is not a month that would require him to report under Cora, period. He was there in August and he completed a transient offender registration form that was explained that while he listed his brother's address as a current physical address, that is a common thing that happens, that this is maybe where they might most likely be found, but that they are then required to list other places where they frequent. And in this case, it was walking around on a street in Wichita and frequenting a charitable kitchen.
But does it say on there where he could be found during the day? I mean, it looks like she testified this is where he could be found during the day on the change information form.
I would have to look closer at that form, but I think it explains I think her testimony was pretty self-explanatory, that he was there specifically. She testified, defendant, he was transient, which is how anyone would have to report it. And that was actually, I can narrow that down. It was volume 5, pages 159 and 165.
Well, that's where she says he's transient.
He reported to her that he was.
Okay. And then
he registered.
That's 154 and 55.
159 and 165.
Right. But that's where on 159, he says, that it was based on this 151 and 152, he was considered transient because he wrote locations where he could be found during the day on the change of information form, which is during the day I walk around Broadway and the Lord's Diner. That's at page 151 and 152.
And I think it's my review of 151, and as I have set it forth in my brief, the defendant's transient registration lifted, as I said, a quote, current physical residence at his brother's house, but it included his notation, I walk around Broadway and the Lord's Diner. Ms. Kastner then explained that defendant told the offender registration unit he did not actually reside at his brother's home, but that he went there during the day. And that was at record volume 5, page 160.
Page 160.
Correct.
Okay, whether or not one is transient is a conclusion, right? I'm transient. That is a conclusion based on something.
Correct.
Okay, how much confidence should we have that the jury would not have made a different decision if they had understood the 3-day, if they had been advised of the 3-day rule and the 10-day?
I'm going to answer that in 2 ways. And my first answer is, I don't know what the defendant wanted the jury to be instructed on, because at one point it was the statutory definitions, but in his petition for review, it's something totally different. So I don't know what exactly the defendant was wanting the jury to be instructed upon here. And my second answer would be that I have the utmost confidence that this wouldn't have mattered. That's the clear error standard of review here. If these instructions had been given, the jury would have, to have acquitted, they would have had to believe defendant's brother over everyone else. They would have had to conclude that defendant resided, and I'm just going to use the statutory language because that I think is what is the most important here, that he maintained with regularity or temporarily his person and property. There was no evidence that he had any property at his brother's home, not even from his brother. Let's see. And then that leaves us with just the presumption. that could have maybe been instructed upon. And the presumption that the statute provides is that an offender resides at any and all locations where the offender stays, sleeps, or maintains the offender's person for, and this is the important part, 3 or more consecutive days or parts of days, or for 10 or more non-consecutive days in a period of 30 consecutive days. Even with that presumption.
That's in the statute?
Yes.
Okay, and so was that provided to the jury?
No, and it wouldn't have mattered even if it had been, because there was no evidence that the defendant that the presumption would have applied.
I thought the brother testified that he slept at his house, slept on his couch, his brother's couch, through the month of September, up through his birthday, which was October 4th. You remember that very clearly, that was a date that he took drove his brother to register because it was his birthday and he remembered it. And then shortly after that, the sister-in-law loses her patience with the situation and says he can't stay there any longer. But the way I read the brother's testimony, it's a fair inference that he was there most of September and the first part of October.
What I would suggest is that what Your Honor is positing is essentially reweighing the brother's testimony. His brother's testimony was not that clear, with all due respect.
Well, I'm just suggesting that there is something there. I don't, so to push back on that.
So I guess
what bothers me from this is perhaps the misleading part of this without the jury instruction, because you had the state's witnesses. Granted, I think the KBI representative did use close to statutory language, but the 2 witnesses from the sheriff's office both repeatedly referred to he didn't have a permanent residence. He didn't have a permanent residence. And then I was just curious how that was argued, and looking at the state's closing argument, that's what the prosecutor argued. The prosecutor repeatedly told the jury he was a transient. He had no permanent address. That was said at least twice. So why didn't that mislead the jury to think that what they needed to look for was a permanent address?
I do want to start with one point regarding the brother's testimony, and then I will directly answer Your Honor's question. And that the brother's testimony began that the defendant only was with him on and off during 2020 and 2021. At another point, he was pretty much from August till October. He was there. Then he tries to clarify. Then he tries to hone it down. Then it's just he was asleep on my couch every day. I remember that. And that is what the jury found to not be credible. So anything that goes against that, or that would find John's testimony credible, is something that this court can't do under its analysis. And then in regard to whether or not this would have been misleading, it wouldn't, because nobody legitimately disputed that the defendant was transient. He had his brother testify that maybe he was there some of the time, but that clearly was not credible.
What was the evidence of where the defendant slept from the state's perspective?
From the state's perspective, the evidence of where the defendant slept from the defendant's own mouth was that there was not a clearly identifiable place that he was.
No, I'm not. You keep, I mean, it appears to me at least that you keep flipping the burden of proof. Like the defendant didn't come forward with evidence, et cetera. I mean, the state still has the burden to prove transience. So what was the evidence the state put before the jury that this defendant did not have a fixed or identifiable sleeping place during this time?
I guess what I would say is that just sleeping somewhere doesn't.
What is it? Should I construe your answer that you didn't have any evidence?
No, you cannot.
Well, then what is the answer? What is the evidence that the state put on about where this defendant slept during the relevant period?
I guess my first answer would be, I don't know that simply where someone sleeps is relevant to whether or not that is a residence. But my second point would be that the defendant himself reported to the offender registration unit that he was transient. He appeared in August He wouldn't have to otherwise. He claimed to have appeared in September. He wouldn't have to if he wasn't.
I understand those are all, I mean, you can, I suppose, have the sort of thinnest of inferences if you presume the defendant has a proper legal understanding of what it means to be transient. But I'm asking about concrete evidence. I mean, was there any?
Was there any concrete evidence from the state's perspective of where the defendant was laying his head at night? Concrete evidence, I don't think that there was. And but again, at the end of the day, I don't think that that matters here.
Why not? That's what the statute talks about.
Well,
stay, sleep.
That's one of the things that can lead,
Would you agree with me that if this defendant, in fact, slept at his brother's house every night, I mean, I don't even think every night's required, but if he did every night, that he would be, as a matter of law, not transient?
If the defendant, he would have to, for his brother's house to have been his residence, he would have to maintain his person and property there. Number one.
No, the statute says stay, sleep, or maintain with regularity one's person and property.
Correct. So he would have to have slept there, his person with his property there, for there to have been direct evidence that was his residence. The only other thing, again, that we would have reached would have been a presumption, which the state continues to assert was easily overcome by.
I'm not even talking about the presumption. I just think in order for the state to prove the element of the crime, doesn't the state have to put forward evidence that he did not sleep in the same in an identifiable place over this period of time? That's what the statute says.
The statute says to stay, sleep, or maintain. I mean, I could stay here for a few hours. I could go take a nap in the attorney's room. This isn't my residence. So, I mean, that would be tumbling down a whole nother definitional rabbit hole that I don't believe was necessary based on the evidence that was presented here, which was that John, the brothers, the only one that gave any indication that the defendant was at his home with any level of regularity, and the jury explicitly, clearly found that to have not been credible. The credible evidence was the defendant's statements to the offender registration unit that he's transient.
Yeah, the credible evidence was a bunch of conclusory statements made by the defendant himself and other state officials, and then people testifying, all to the legal conclusion that he was transient.
And doesn't even the defendant's statement support this definition? Because he said he didn't sleep at his brother's house, but he stayed there during the day. He went there during the day, I should say. But when the fact that he said he went there during the day, isn't that the definition of stays at a particular address?
I don't think so. To go there, you have to keep your person and property there, and that's where I would circle back.
No, there's an or, right?
Sleep or maintain with regularity or temporarily one's person and property. There was no evidence that he kept any property at his brother's house at all, ever. Not even from John.
Did he have any property?
He at least had some clothing that we know because of his photograph that was attached. We know
clothes that he was wearing.
We know at least that because this was not the issue at trial.
Yeah,
that's the other thing that we continue to run into is that if there'd been anything presented to press this, perhaps there could have been additional.
Whose burden was it to present it?
It's the state's burden to present evidence to satisfy its burden of proof. But I believe that the evidence here did.
I want to probe just a little bit about the inference you're asking us to draw about his having to report in August. As I understand KBI Representative Ryan Hansen's testimony, he explained that the local agency, in this case, the Sedgwick County Sheriff's Office, could just tell an offender, you have to report at a more regular basis. And as I understood the testimony of Lena Kastner, they did tell him that he needed to report monthly. So does that really allow us to draw an inference other than they ordered him to report and he did at least for the month of August?
I I guess I'm not as, maybe I'm not as familiar with the point in Mr. Hansen's testimony that you're talking about, because the points, and I guess it's partly because his testimony was just basically an overview, and the focus of his testimony was he gave a couple of definitions and then explained that transient offenders are required to register every 30 days. That was record volume 5, page 131. Again, there was just, I don't see anything here that would have said.
And unfortunately, I can't give you a record citation. It's just kind of my memory of as I read it, read that testimony. And I did not look at the statute to see if there was any support for his testimony, but
then, and fair enough. And I mean, I think it's also relevant to point out Clopton, the deputy's testimony was that he's the one that really explained that the defendant's listing of an address was just because he stays there from time to time, but otherwise he's homeless, at which point they provide free locations where they frequent, sleep near, intersections, shelters, etc. His was one of those. These folks knew the defendant, and they knew that he was transient. The defendant knew he was transient. And any argument to the contrary at this stage is simply one that is asking for the evidence to be reweighed in this case. If there are no other questions, I would ask, I mean, if there are any, I would take them, but if there are not, I would respectfully ask that this court uphold the defendant's conviction for failing to register in September of 2021. Thank you very much.
thank you. Ms. Tran, that last statement prompts a question. Just a clarification. You are not challenging the conviction for the October failure to report. Is that correct?
That's correct.
Okay. So it is just September we are focused on.
Just the September, the one where he was the transient offender conviction. And if there are no other questions, I would waive my rebuttal time.
I have a question about the form that the Mr. Ballard filled out. He listed an address, and I believe it was in response to what's your residence or where do you live? Is that correct?
I'm not certain what it was in response to, but it is clear that he did list the address.
And that was his brother's address. Correct?
Yes.
And then the box that he wrote on was, during the day I go, I often go here and here, correct?
Correct. So it says, it's a blank box and it says, I walk around Broadway in the Lord's Diner on the form.
What's the question above it?
There is no question above it. It looks like it's kind of just like a blank box for extra information. There's
just, is that what it says? And I could look it up. Sorry, but does it just say extra information or anything?
It doesn't say
in the box
above that on the box.
So
It's completely blank, and then at the bottom it says I walk around Broadway in the Lord's Diner, and then there's a black line, and below that is the signature block.
Okay, is there anything in the box where he listed the address?
The box states current physical residence, and then street, apartment number, city, etc.
And that's on the other, that's on the
first
page.
And that's where he listed
That's
the
typed in.
address.
That's where he listed.
That's typed
Okay.
in.
Thank you. Thank you.
Thank you. If there are no further questions, we would ask that this court vacate Mr. Ballard's conviction. The state did not prove beyond a reasonable doubt that he was transient. But even if this court does find that there's sufficient evidence, Mr. Ballard should still receive a new trial because the jury wasn't instructed on CORE's definitions of transient, residence, and resides. Thank you.
Thank you. Thank you to both counsel for your arguments. The court will now be in recess until 10:30.